Liberty interest for prisoners. In defining liberty, the court has struggled most with cases involving prisoners. Over the past quarter of a century, the court has shifted its approach several times. Initially, the court indicated that prisoners have a liberty interest when an important matter is at stake. The court, however, later moved away from this approach and repeatedly held that liberty interests for prisoners are a function of statutes and regulations. Prisoners have liberty interests when the relevant statutes and regulations create them. However, most recently, in Standen v. Connor, the Supreme Court backed away from this approach and held that regardless of the contents of statutes and regulations, there is a liberty interest only if there is a significant deprivation of freedom that is atypical to the unusual conditions of confinement. In Morrissey v. Brewer, the Supreme Court held that revocation of parole is a deprivation of liberty that requires the provision of due process. The court emphasized the importance of the interest to the individual. When out of parole, an individual can be gainfully employed and is free to be with family and friends and to form the other enduring attachments of normal life. This, of course, is taken away if parole is revoked, and the Supreme Court found that there was a liberty interest in remaining on parole because ending parole inflicts a grievous loss on the parolee and often on others. In other words, Morrissey found a liberty interest based on the significance of the interest to the parolee rather than focusing on the specifics of the state law involved. Likewise, a year later, in Gagnon v. Scarpelli, the Supreme Court ruled that the revocation of probation is a deprivation of liberty requiring due process. The court explained that revocation of probation is constitutionally indistinguishable from a revocation of parole. Soon after these cases, however, the court shifted its approach and based its determination on whether there is a liberty interest on the content of the statutes or rules, rather than on the importance of the interest to the individual. For example, in Wolf v. McDonald, the Supreme Court held that prisoners have a liberty interest in good time credits awarded under state law. The court explained that although a state need not give prisoners good time credits, the state having created the right to good time, the prisoner's interest has real substance and is sufficiently embraced within 14th Amendment liberty to entitle him to those minimum procedures required by the Due Process Clause to ensure that the state-created right is not arbitrarily abrogated. The court said that a person's liberty is equally protected even when the liberty itself is a statutory creation of the state. In other words, Wolf found a liberty interest based on the expectations created by state law rather than based on the significance of the credits to the individual prisoner. The court applied Wolf in Meacham v. Fanow when the Supreme Court held that prisoners do not have liberty interest in remaining in minimum security facility as opposed to a maximum security facility unless the state or federal law clearly creates such an expectation. A prisoner argued that a transfer from a minimum security facility to a maximum security facility obviously meant that he had less liberty. The court disagreed and declared, "We reject at the outset the notion that any grievous loss visited upon a person by a state is sufficient to invoke the procedural protections of the Due Process Clause. That life in one prison is much more disagreeable than in another does not in itself signify that a 14th Amendment liberty interest is implicated. In dissent, Justice Stevens, joined by Justice Brennan and Marshall, disagreed and argued that neither the Bill of Rights nor the laws of sovereign states create the liberty which the Due Process Clause protects. It is basic freedom which the Due Process Clause protects rather than the particular rights or privileges conferred by specific laws or regulations. The conflict between the dissent and the majority was over how to determine when a prisoner has a liberty interest. For the dissent, the deprivation of liberty occurs when a prisoner is denied important freedoms regardless of the contents of the statutes or regulations. For the majority, a deprivation of liberty occurs if there is a removal of a freedom created by a statute or regulation. So this is the present day approach. After Wolf and Meacham, the question becomes what statutes and rules create liberty interests. The Supreme Court focused on whether a law or rule was sufficiently mandatory so as to create a reasonable expectation on the part of the prisoner. For example, in Greenholz v. Inmates of Nebraska Penal and Correctional Complex, the Supreme Court held that the existence of a parole system is not enough to create a liberty interest in parole. Rather, there must be specific requirement in the law that transform parole from a mere hope to an entitlement under the particular circumstances. The court found that Nebraska created a liberty interest in parole because state law allowed the denial of parole only under specific statutorily defined reasons. And because the law only allowed denial only if there were specific findings to support the decision. The court emphasized that the word shall in the state law created a legitimate expectation to release on parole unless one of the statute's exceptions was met. Okay, so that's how Nebraska created a liberty interest. The word shall in the state law created a legitimate expectation of release in Greenholz. Okay. The contrast in approach between Morrisey versus Brewster and Greenholz is striking. Morrisey found a liberty interest in parole because it determines a person's freedom. Greenholz held that there is a liberty interest in parole only if the state law makes one by its mandatory language. The Greenholz approach was followed in a series of cases spanning over 2 decades. For example, the Supreme Court has held that a prisoner has a liberty interest in not being placed in disciplinary segregation or being transferred to another, more restrictive facility only if the state law creates such an expectation. In Hewitt v. Helms, the Supreme Court found that a prison had to provide due process before placing a prisoner in administrative segregation because state law had created such a liberty interest. The court explains because only if the state law creates the expectation. Okay. Because, wait, where am I? The court explained that generally prisoners have no liberty interest in being confined in one place as opposed to another, but the court said that the state had done more than issue procedural guidelines. it had used language of an unmistakably mandatory nature or character and made it clear that a prisoner would not be placed in administrative segregation absent specific substantive predicates. Similarly, in Connecticut Board of Pardons versus Demschott, the Supreme Court found that the prisoner did not have a liberty interest in having a review of a request for commutation of life sentence. The court explained that state law did not create an expectation that sentences would be commuted, even though in practice the review board commuted most of the life sentences in the cases it considered. The court said that the Connecticut law governing commutation of sentences did not provide particularized standards or criteria to guide the state's decisions. In other words, in deciding whether a prisoner has a liberty interest, the court would examine the statutes and regulations governing the prison. If there were written in mandatory language and created a legitimate expectation of a benefit, then the court would find a liberty interest. The court expressly expressed, oh my God. The court expressly stated this in Kentucky Department of Corrections v. Thompson, where it declared, "We have articulated a requirement that the regulations contain explicitly mandatory language, example, specific directives to the decision maker that if the regulation's substantive predicates are present, a particular outcome must follow, in order to create a liberty interest." In Thompson, the Supreme Court held that prisoners in Kentucky did not have a liberty interest in visitation, even visitation from family members, because the regulations lacked the requisite relevant mandatory language. Although in all of these cases the court emphasized the content of the laws and regulations, did not fit the pattern, and where the court found a liberty interest primarily based on the importance of an interest to the prisoner. For example, Vitek v. Jones, the court held that the prisoner deprived of liberty when transferred from a prison to a mental hospital, held that a prisoner is deprived of liberty when he's transferred in that way. The court, in part, focused on the content of state prisons' regulations and concluded that they created an expectation that the inmate would be kept in prison facilities and not moved to a mental hospital without a proven need for treatment. But the court also emphasized that there was a loss of liberty because confinement in a mental hospital likely would mean the imposition of mandatory treatment and also a realistic possibility of stigma. The clear implication of VTEC is that prisoners have a liberty interest in not being transferred to a mental hospital regardless of the content of the specific laws or regulations for that prison. Really? Alright, well, let's be more specific then, because all this other stuff about how it had to do with the prisons, regulations don't matter. Also in Washington v. Harper, the Supreme Court recognized that prisoners have a liberty interest in avoiding the involuntary administration of antipsychotic medications. The court made it clear that independent of any state law or regulation, prisoners have prisoners have liberty interest in being free from the involuntary administration of psychotropic drugs. The court found the state law met the requirements for procedural and substantive due process before the administration of these drugs. Prison regulations required the prisoner be given at least 24 hours notice before the administration of medication. So procedural and substantive due process before the administration of drugs. 24 hours notice. And it provided the opportunity for a hearing before health professionals and prison officials. The court found that this was procedurally adequate to meet the requirements of due process. Thus, up until June 1995, a liberty interest for prisoners could be found either if the prison statutes and regulations were written in mandatory language and created such an interest, or if the interest was so important that the court would deem it to be part of liberty regardless of the content of the statutes or regulations. In Sandin v. Connor, however, the court called into question the approach of finding liberty interest based on the content of statutes and regulations and shifted back to the approach that determines liberty interest based on the importance of the interest involved.